let's go on the record on cause number DC 233337, Dowdle versus MMWKM Advisors LLC. Counsel, make your appearances.
Good afternoon, Your Honor. This is Patrick Yarbrough. I'm here on behalf of Judgment Creditors, MMWKM Advisors LLC, and Ken Marafe.
Good afternoon, Your Honor. Garrett Pronsky for Joe Dowdle.
And Your Honor, I'd also like to introduce Ms. Dana Lipp, who is the receiver that we proposed appointing in this case. She's here in order to answer the court's questions if you have any.
Okay,
Thank you.
let's proceed.
All right. Well, thank you very much, Your Honor. So as you know, we're Judgment Creditors, MMWKM Advisors LLC, and Ken Dowdle. I'm here to as the movant on our motion for receivership. There was a judgment entered in this case by Your Honor last year in June. Since then, defendant has not, or judgment debtor has not appealed the case, has not appealed the entry of your final order. Neither has judgment debtor filed a supersedious bond or deposit. Therefore, the judgment remains unpaid. The only amount that has been paid is $154, which was paid pursuant to your turnover order back in, I believe, December. There has been an unfortunate lack of forthcomingness and candor with both counsel and this court, which is why we're here moving for receivership. Your Honor, if you saw our reply brief, you'll see that today the judgment debtor, and I'll, if you don't mind me sharing my screen, I'll go ahead and just show you the goods.
Okay.
After, and by the way, I've already submitted some exhibits that will be pre-admitted, or that the parties have agreed to pre-admit. So this is exhibit number one. Just last week, in his response to the request for appointment of receiver, Mr. Dowdle testified in a declaration filed with this court that he did not own any exempt property, as you can see here in paragraph 2.
Any non-exempt, I think, right?
Oh, I'm sorry. Excuse me. Mr. Dowdle testified in his declaration filed in the court 1 week ago that I do not own any non-exempt property. Then, just this morning, I heard from Mr. Dowdle's counsel, and in Exhibit 2, Mr. Dowdle's counsel stated, Patrick, I was sent to you, it's hard to read this, there's some typos. A check was sent to you overnight on Thursday from Joe Dowdle, payable to the sheriff in the sum of $1,291.58. This sum represents an advisory fee received by Dowdle that is not part of the employment with WHAM. I sent this to you to expedite getting it to the sheriff. Please send it on to your appropriate connection at the sheriff's office. Thank you. So, Your Honor, just in the past week, as this motion was pending, Dowdle changed his position from last Monday to I do not own any non-exempt property to now Mr. Dowdle's counsel has sent me a check from Mr. Dowdle for $1,291.58. And the reason this is concerning, Your Honor, is that this isn't where it ends. Mr. Dowdle, at the last hearing, was shown to have signed an agreement with a third-party investment advisor representative agreement. That party was Worth Asset Management, LLC, which provides back office services for Mr. Dowdle as he provides investment advisor representative services for clients. And in this agreement, which was presented to your court on October 23rd, 2023, when we got the turnover order issued, and this was uncontroverted at the time, it stated that Mr. Dowdle was an independent, excuse me, it doesn't highlight well, but here in the middle of the page, you can see he has independent status with WHAM and that he performs his advisory duties as an independent investment advisor and not as an employee. That's page 1 of Exhibit 3. Then on page 10, you can see that the fee to be paid to Mr. Dowdle is a fee payable to the IAR of 80% on the gross fees collected by WHAM from IAR's customers. Okay, so as you can see, there's a tripartite relationship here. There's Mr. Dowdle on the one hand, there's WHAM on the other hand, and then there's the clients that are called IAR's customers on the third. And so under this agreement, Mr. Dowdle has the fees for the assets and the custodies that he has under management paid to WHAM first, who then pays on to Mr. Dowdle 80% of those gross fees. So, Your Honor, at our last hearing, I presented this to the court, and this court incorporated this contract into its turnover order by name. But nevertheless, Mr. Dowdle's counsel did not provide, either through discovery, which already had pending things on point to provide a new agreement, or at the hearing itself, the existence of this agreement, which is the same thing, Your Honor. This is Exhibit 4. This is the same agreement, except it has a couple of very interesting tweaks. Here, instead of saying independent status with WHAM here on page 1, it says that Mr. Dowdle on line 3 will conduct his activities as a W-2 employee. Okay, that's interesting. And then but nevertheless, on page 10, Mr. Dowdle is compensated here, not with a wage, not with a salary, but once again, a fee payable that varies depending on how much is collected from the IAR's customers. Okay. So what we have here is a relationship which hasn't changed at all, wasn't disclosed to the judgment creditor or the court, but labels Mr. Dowdle an employee. And I think it's very important that the court notes this is exactly why we need a receivership order. This is too cute by half. And I think that's the reason why they didn't want to present that in court last time. They thought it's better we get a turnover order on that moot contract so that any fees under that old contract, which we know we're not even receiving payments under anymore, would have to be turned over, but not this new one, which we claim is somehow an employee contract. But that said, you can look through Exhibit 4, Your Honor, and nowhere from top to bottom does the word wage appear. Nowhere does the word salary appear. What you have here is the same thing we had in Exhibit 3, which is actually disclosed to the court, which is fees paid based on assets under management that Dowdle is handling as a independent contractor for Worth Asset Management. Okay, so also not to retread too much ground, since I assume you've read the motion papers.
I have.
Mr. Dowdle has a bank account at Wells Fargo, which we already proved up based on discovery. Mr. Dowdle has not produced any updated records of this bank account, even though I repeatedly asked for them. But nevertheless, owning a bank account is a non-exempt asset. So in addition to the cash that Mr. Pronsky acknowledged were sent to my office in Exhibit 2, and in addition to the IR agreements, Exhibits 3 and 4, which pay fees that are not at all salary, they're not a fixed amount for a fixed amount of work. They do not impose the kind of strictures that an employment relationship does. So in addition to that, we also have this bank account. And I'd like to point out, Your Honor, and this comes from a case that's cited in our reply brief, which is Klinek versus Luxyard Inc. This was decided in 2023 by the 14th Court of Appeals. Here, in that case, on page 838, the court finds that once cash is traced to the judgment debtor, he's presumed to have possession, and the burden shifts to him to account for the funds. And so here, as we can see, Mr. Dowdle said on last Monday that he had no non-exempt assets or property. That obviously changed in the last 7 days. Mr. Pronsky emailed us acknowledging the existence of the amount on this check, which is attached as Exhibit 8, in which you can see I have right here in my office. Mr. Dowdle obviously has enough funds for this check to clear, which Mr. Pronsky encouraged me to pass on to the constable, not the sheriff, it's actually the constable in your order. And so I think it's abundantly clear that we need a receiver appointed. Obviously, the assets are a moving target. There's been a lack of disclosure, both in discovery and in court hearings with this court. And for that reason, we're moving for appointment of a receiver, as well as a proposed order that includes language that finds that this Exhibit 4 IR agreement, which wasn't disclosed at the last hearing, pays non-exempt fees, regardless of what you label Mr. Dowdle under case law, which is cited extensively in our reply brief. These are non-exempt fees that needs to be found in the order to be a non-exempt asset in the income stream as well. And we also need an order that requires Mr. Dowdle to be more forthcoming with respect to his sources of income. Mr. Pronsky, as you can see in Exhibit 2, which I'm switching back to here, said that the $1,291.58 that were sent to us represents, quote, an advisory fee received by Dowdle. What we don't have, Your Honor, and which is owed to us in discovery, is the check that Mr. Dowdle received of this amount or whatever amount he received. We don't have a check that was endorsed over to the sheriff or the constable. What we have here is a moving target. It shouldn't be up to the judgment debtor with a record like this to decide in his own judgment what he does or doesn't have to turn over in discovery or to the constable or receiver. It should be up to this court. And that's why we're seeking this receivership order. And Your Honor, I also, again, like I said at the beginning of the hearing, have brought Ms. Dana Lip here to answer any of your questions. Ms. Lip has, I understand, served as a receiver appointed by this court in the past, and that was in case number DC-19-19003. Ms. Lip is a University of Texas Law School graduate who has extensive experience in this area, both representing receivers and serving as receiver. And for that reason, we've provided her as a recommendation in this case, and we'd be more than happy to present her as a witness if you'd like.
Not at this point. Let me hear from the other side.
Yeah. Good afternoon, Your Honor. Garrett Pronsky for Joe Dowdle. Your Honor, I think we're talking about three separate items. One is Mr. Dowdle's source of income that he uses to provide for his family, and we're talking about a non-exempt check that he received that he told me about that we immediately turned over. And we're talking about a bank account that has, according to Mr. Yarborough's records, a balance of $605 as of July of last year that was whittled down because it's used for insurance, a drawdown on an insurance that comes out as a direct drawdown on a monthly basis. It decreased down to $154. And so after the turnover order was entered, where you ordered all of the non-exempt assets to be turned over, we turned over the balance of that account. The check that was received from the client for a small check for $1,200 for some advisory fees, my client called me and said he'd received the check, and I advised him that I didn't see how that was anything other than non-exempt income, and we turned it over. And to get it quickly to the sheriff, I Federal Expressed it to Mr. Yarborough last Thursday. And the other thing that we're talking about here is the income under the independent agreement, or the the investor advisor agreement. And again, Your Honor, this is the income that Mr. Dowdle earns on a monthly basis to support his family, which is a wife and two girls. To be clear here, the judgment creditor is trying to take away all of Mr. Dowdle's income and leave him with nothing to make a living with. What transpired last year in August was that, and it was definitely because of the judgment, Your Honor, this agreement was switched to an employment agreement from an independent contractor agreement. Now, there is that is an absolute right that exists under the prior agreement, which says that it may be terminated at any time by either side. There was no money that was owed.
If he's a W-2 employee, then how did this additional check come about?
It was from a different source.
And what is the other source?
I'm going to have to look at that.
And does that source have additional money coming in, or is it just a one-time check?
If there is nothing that is owing at this time, and if anything comes in, he'll turn it over just like he turned this one over. There's no issue here. There's no non-exempt asset because we have turned that over as of Thursday to Mr. Yarborough, and there is no other income. Based on the fact that we've had to turn this over, I doubt seriously Mr. Dowdle will do any more work that is outside his employment agreement with other people because he knows that he's got to turn it over. And he and I have had a very candid conversation about making sure that the turnover order is adhered to completely. I have another situation going on with Mr. Yarborough in the Collin County Court. And Mr. Yarborough filed motions for contempt and all sorts of things on a regular basis, and we're going to make sure that this matter is as clean as it possibly can be, and that that when this court has ordered him to turn over all non-exempt assets, that all non-exempt assets will be turned over. Getting back to this,
why is there? Okay, there's another case in Collin County where there's been a contempt motion filed by Mr. Yarborough.
Excuse me, Judge Hoffman, if I may. That case actually had a receiver move for contempt, and Mr. Pronsky actually withdrew from that case, or at least moved to withdraw from that case over our opposition when opposing counsel, who Mr. Pronsky was working with, moved to recuse the judge in that case, Judge Baressa, for the first of 2 times. So Mr. Pronsky is not an officer of the court representing a party in that case any longer. And for that reason, or if he is, he hasn't shown up.
So okay, you guys are going through a lot of details. This other case involved.
Please finish my presentation.
It's a separate case, Your Honor.
Well, I'm just trying to get some details on this.
So
let me just ask a question. So there's another case involving the same defendant.
No.
In Collin, or a different defendant?
Yeah, and Your Honor, if I could, I can explain it with very, very quickly here. There are 2 individuals that Mr. Yarborough's client sued. One's name is Mr. Floyd, and one is Mr. Yarborough. Mr. Floyd's case is pending in Collin County, and the judgment creditor that Patrick Yarborough represents and the receiver have been extremely aggressive in their collection efforts, again, to try to receive the income from this individual and have filed contempt motions, and there's been basically a nuclear war going on there. When my co-counsel filed a motion to recuse the judge, I withdrew because I did not agree with that effort. But my point being, Your Honor, that
Your Honor, may I respond before we move on from that topic, because I feel like it's inappropriate for Mr. Pronsky to mischaracterize those proceedings.
May I finish my presentation, Your Honor?
I'm trying to figure out how are these 2 cases related again?
Your Honor, let me just say the only relationship is the same plaintiff. There are 2 different defendants. Mr. Pronsky is not participating in the other case, and the judge in that other case found that Mr. Pronsky was not candid with the court and wasted the court's time, and she actually is the one who asked the parties to file briefs on whether she should issue a show cause order, which she did issue, and then Mr. Pronsky bowed out of the case because opposing counsel in that case moved to recuse the judge.
But it's not involving this same defendant.
Not at all.
Not involved. And the judge did not find me lacking candor. I am going to just move on from there.
Your Honor, I'd be more than happy to submit.
I'd be more than happy to submit. Let him finish.
Please finish my presentation and have Mr. Yarborough respond, as opposed to.
Good afternoon, 68th District Court.
Hi there.
Go ahead.
So, Your Honor, the agreement was switched to an employment agreement, and there is half of, and this is in the declaration, half of the people that work for WAM, which is the employer, work on an employee basis, and half work on an independent contractor basis. They're given the option to be either W-2 employees or to be independent contractors. Half have picked to be W-2 and half have picked to be independent contractors. Mr. Dowdle, having received a judgment against him and having a contractor amounts would be non-exempt assets, opted to become an employee so that his sole source of income would not get taken away from him, and he would be left with absolutely nothing to pay his mortgage and pay to support his family. And when we talk about lack of candor here, Your Honor, Mr. Yarborough says in his reply that he filed today that the first time that I ever gave him that employment contract from August of last year was last week. That is absolutely false, and I've got some emails here that prove that. And unfortunately, his reply was filed today, or I would have filed these with the court. But Mr. Yarborough and I spoke about that, and he said, well, I don't think this is in December of last year, and he said he didn't think he had that agreement. So I wrote him an email on December 7th last year at 1:03 p.m. that says, Patrick, this has been provided to you previously, but just to make sure you have this, I'm forwarding it again. And I attached a copy of the August agreement. He responded back to me and he said, really, ? When ? And then he said, please start to copy everyone on the case on emails. I'll be on my honeymoon for 2 weeks, so it's critical you include co-counsel on emails going forward. And he attached that same agreement from August, not just once, but he attached it twice, which obviously was a mistake. But the point is, he had it and he attached it in an email he sent to me in December. Now, this agreement, he says, I hid from the court and hid from him and didn't let him know about it until last week. And that is absolutely not true in light of those two emails. But Your Honor, the point of this is the declaration of Mr. Dowdle shows that not only do half of the people that work for his company employ themselves as employees, Mr. Yarborough's client is in the same line of business and also has representatives that are investment and retirement planners. And all of those persons that work for Mr. Yarborough's client are employees. And so this is not an unusual situation. This is a standard in the industry to be an employee. And as I said, and it's in the declaration, and Mr. Dowdle knows this because he used to work for Mr. Yarborough's client. And he says that all of the people that work there as retirement planners, investment advisors, are all employees on a W-2 basis. And so all Mr. Dowdle has done to protect his only source of income that he supports his family with being taken away from him every single month, he has switched from an independent contractor to an employment situation, and he now gets his W-2 and he gets his taxes and other deductions taken out of his check. And so he is an employee. There's no evidence to the contrary. And that income, which again is his sole source of income, is, obviously, if that's taken away from him, he's either destitute.
You're kind of, I appreciate that you're kind of repeating yourself at this point. So let's, I want to hear from Ms. Lip real quick. It seems like a bit of a fool's errand here. Why would we appoint a receiver? It doesn't seem like there's any assets here. You're muted, Ms. Lip.
I have not had a chance to review the investment advisor agreement, but I can surmise that there's going to be some kind of dispute as to whether those compensation is really still independent contractor payments for fees for assets under management, or whether it truly is an employment agreement for wages.
Okay, that makes sense. All right, I will go ahead and grant the motion to appoint a receiver. And do you have any objection to the form of the order that was provided, Mr. Gronsky?
Yes, I do, Your Honor, and I redlined the agreement, the order, which is extremely overbroad, and I attached that to my response. So the court actually has my red line version. But Your Honor,
Your Honor, may I add that I actually filed a new proposed order today, which sets forth that the new investment advisor agreement, which, by the way, Your Honor, I did forget about that email exchange with Mr. Pronsky while I was on my honeymoon. That's why I asked him to include other team members, because I wasn't really dialed in. But that said, the point stands that in the Worth Asset Management Group could have made him into a true employee that receives a set salary, like members of my client's firm do. They get a set salary and then they get bonuses. The set salary is the part that's exempt. Okay. There's no exemption here for commissions or just kind of free floating fees like this on assets under management. And for that reason, Your Honor, I ask that you enter the order that we submitted today in Word, which includes this agreement. If Mr. Dowdle can get his employer to pay him a set salary, which will be part of kind of what his average fees are that he brings in, and then he gets and then he has basically an exempt part, which would be the salary or wage, and then there'll be a non-exempt part, which is like the part that varies. That would make sense, and I wouldn't even bother contesting that. The truth is, they didn't actually make this into a wage earning relationship, and you can compare exhibits 3 and 4, and you can see there's like a word changed from independent advisor to W-2 employee. It's just, you can't just label something that way. It's the economic relationship, and they can change that, but it's never going to be exactly the amount that they're paid under this contract, if that makes sense, Your Honor. So what I ask is that you enter the order we submitted.
So let me understand the history on the submitted orders. So Mr. Pronsky, I guess Mr. Yarbrough submitted an order, you did a red line, and then Mr. Yarbrough, you did a new order, is that right?
Yes, Your Honor. I submitted a new order, which, like I said, the main change is just that I add in some content relating to the agreement.
Mr. Pronsky, have you seen that? Have you seen that order?
I looked at it, and the only thing it appeared to add to me was the receiver's name. So, and there was no red line submitted to me. So, and it just was filed today. So I have not had an adequate opportunity, but I can tell the court big picture the issues that I have with the order. And as I said, there's a detailed red line that is attached to my response. But Your Honor, I do strongly object to any the court making findings as to the ownership of assets with no evidentiary support, and this order does that, which I think immediately creates a problem that it sounds like we have to litigate, which is this employee's sole income that he earns for his family every month, subject to being taken away from by the receiver. Secondly, the order allows the receiver to collect assets directly from non-debtor third parties, and that goes beyond the turnover statute and the receiver provision in the turnover statute. You can't get a turnover against third parties. You have to file against them and give them notice and an opportunity to be heard. This order allows the receiver to seize partnership interests, which I don't think there are any, but Texas law only allows the imposition of a charging order. The order allows the receiver to change the locks of the judgment debtor's exempt residence and to obtain and redirect personal mail of the judgment debtor. It's an extremely onerous order. It allows the receiver to recover files of the judgment debtor that are in possession of the debtor's attorneys in violation of the attorney-client privilege. And I also object to, Your Honor, there's a lengthy provision that provides for production of documents that should be obtained through post-judgment discovery. And in fact, Mr. Yarbrough has done that post-judgment discovery. We've responded timely, and we've turned over documents. He's not filed a motion to compel or any motion saying that there's any problem with our responses. And now what he does is put all of those production of documents, which goes years back, and does it in the form of an order. And Your Honor, I am very concerned about that provision because of the use of the contempt motions that Mr. Yarbrough has done on behalf of this client in that other case that I personally witnessed. Having Your Honor order the turnover of, or basically post-judgment discovery production of documents, and my client hiccuping on something immediately is going to turn into contempt. And the way this should be handled is through post-judgment discovery, which, as I've said, Mr. Yarborough has already propounded post-judgment discovery. And if he has got a problem with the discovery, he can file a motion to compel. So far, he hasn't even sent a letter saying there's a problem.
I will say, I've, in dozens of cases in the past, I have allowed the receiver to obtain documents directly from the slip. Is that something that's allowed, or is that something that's not allowed?
This is very standard in receivership orders and commonly done.
Yeah, that's what I've seen before too. This is what we're gonna do. We're gonna go ahead and let you guys kind of talk out the terms of the order. So if you can, I'm gonna put you guys into a breakout room. You'll have about 20 minutes to talk it out. If you guys can reach some kind of agreement, that'd be great. If not, I'll have you guys come down on Friday and in person, and we can, if I'm done with trial, then I'll hear it. If not, I'll have my associate judge hear it. I think you heard about the trial I have starting. And we'll have you guys just work out the terms of the order. But hopefully you guys can get that all worked out. Okay?
Sure, we'll do that.
So the hearing, Eve, are you there? Give me 1 second.
Sure.
Yes, sir, I'm here.
So Eva, go ahead and reset this hearing to Friday at 9, let's say at 9 o'clock. It'll be in person. Everybody will need to be in person. If you guys can come up with an agreed order, you guys are welcome to cancel the hearing or agreed as the form order. If you can't reach an agreement, then you all need to come down. And if I can hear it, I'll try to hear it. And if I can, I'll send it to my associate judge. Okay, guys?
Your Honor.
Thank you, guys. I got to get to my next hearing. I'm so sorry, Mr. Pronsky. We'll see you on Friday, okay? Thank you so much.
Thank you, Your Honor.
Thank you.
Bye.
Oh, Miss Lip, you're excused. You have a great rest of your day, okay?
Thank you.
Sorry about that. think we have one more hearing today.
Judge, is it Bashir Ahmad versus Ariel Sanford?
Yeah, I believe so. I'm trying to open up my Odyssey real quick. Yes, that's it. Bashir Ahmad versus Sanford.
Yep. We've got it's a motion for substitute service on that one that
Yeah,
needs to
I had
go.
a just kind of sorry, let me open this up real quick. I had a concern with it real quick. So it looks like you filed an amended one. Maybe that'll fix the issue.
I believe so. I think we fixed the
So I guess my question is that you're trying to sue this Ariel Sanford, and let me share screen what I'm looking at so you kind of know. This is the affidavit I believe you attached, and it says that there was a silver Chrysler KJR 3930 in front of the house. And then they called and received a call from Rubio Ramirez and said they don't know who this Ariel Sanford is. So I was trying to figure out kind of, is there another thing? Let's see. So then you, I guess, tried to serve at this other address on Ardenwood apartment, and um, I just don't see any confirmation that these are good addresses. So that's kind of what my concern was.
I think it sounded like the process what the process server told us was that the I guess this ficus address was where her car was, and
I don't see that in the affidavit. The address. You mean on Republic? Is that what you're saying? No,
uh,
that's you. I'm sorry.
no, the
Address on Dutton. Is that
look,
what you're?
are there other pages to yours? The top of page, it says 3 of 4 on mine. Um, First
Um,
amended.
I'm not sure what you're looking at.
Right. Oh, hold on.
Yeah,
Maybe a couple of pages for that.
that one.
Next, there's the page I'm looking at has got like it's a part of a. I guess we attached our email, like our emails, back and forth with the process server too.
Oh,
If
I
you
see what you're
go,
talking about. Okay, it's kind of hard to read on this.
yeah,
Let me
I know
pull
it's
it up.
way, yeah, that's the page though that I'm reading from up
Is
there.
that what you're reading from? Let me take a look real quick. She has a black Challenger registered at her. Okay. Just in the future, uh, just so you know how I do stuff, is it really kind of needs to be in the process server's affidavit for me to consider it.
Mhm.
And this is an email if they, but I'm not going to make a big deal about it. So you're wanting to serve her at this Ficus Drive
That,
address?
that's correct, Your Honor.
All right. Let's see.
Yeah, that was the last.
All right, I'll go ahead and sign this then.
Thank you, Judge. And I will, yeah, I don't know why, to tell you the truth, I have no idea why they told us in an email and didn't add it to the affidavit, but that's what we put, like, well, I guess what we were asking for in our motion and
No
then
worries.
an affidavit. Yeah,
It just will go a lot smoother if it's in the affidavit. So,
sure.
all right. Well, great. Well, you have a great rest of your day.